about the case involving the superintendent in Iowa who is detained by ICE. This is the story about Dr. Ian Roberts, who was born in Guyana, and I'm looking at the New York Times report on this story, and apparently, friends, he is detained right now by ICE because he has a removal order. And you might be saying, how in the world can someone get a job as big as superintendent of schools, right? The chief person in charge of the school system there in Des Moines, Iowa, how could that person be an undocumented individual or someone who has a removal order? We're going to dive into that issue in this unscripted video. And I'm also going to share some thoughts with you about strategy. For instance, if we had this case, what we would be thinking about working on, what direction we would go in to help him out of this situation. Now let's get into it. So on Friday, the superintendent of the public school system in Des Moines, Iowa was detained by ICE. And ICE has issued a statement saying that he had no work authorization and he had faced weapon possession charges several years ago. And he entered the United States in 1999 on a student visa, and he received a deportation order in May of 2024. So now Dr. Roberts, according to the New York Times, it's unclear whether he already has an immigration attorney working with him. He is married, that much we know. We do not know whether his wife is a U.S. citizen or whether he has U.S. citizen children or parents. What we do know is that he is a former track and field star because he participated in the 2000 Olympics for Guyana. And he ran in all these other major races over the years. And he eventually made his way up, all the way up to the position of superintendent for Des Moines, Iowa, their school system. In 2023, he got that big job. And on the website for the school, when they announced that he was going to become the new superintendent, they explained that he is born to immigrant parents from Guyana and spent most of his formative years in Brooklyn, where I'm from. Now, how did this happen, right? How did they miss it? Because now the school system is saying, well, we don't have a lot of answers right now. We don't know what to say right now. And the reason I think they don't know what to say right now is because along the way, they just were not verifying the status. But it is possible, guys, that while he was in removal proceedings, he had a work permit potentially, right? If he had applied for asylum, he would have had a work permit through that case. Or if he had applied for cancellation of removal, he would have had a work permit through that pending case. And so it's quite possible that he got that job in 2023, as reported here. He started that job with work authorization. So he could have potentially passed the I-9 scrutiny that employers are required to complete and go through with new employees as part of the payroll onboarding process. So stick with me for a moment here. So for argument's sake, he went through all of that. He had his work permit and the I-9 was fine, no worries. But his case in removal in immigration court made unfortunately, he got a removal order. A removal order was issued in 2024. It's possible that the school system, his employer, didn't know about the removal case. They might not even have known that he was in removal. But even so, if they had known about it, because he had a valid work permit, potentially, I don't know, I'm just trying to piece this thing together, right? I have never spoken to him. I don't know the full details here, but if the school system had not even known that, or had known that he was in removal, well, because of that valid work permit, they were still fine to have him work for them. It's just that now that he has this work, the removal order, he then lost his opportunity to keep going with the work permit. So that's what I think DHS means when they say here or publicly that he did not have work authorization. And so they had a right to go after him. And when you're in a small jurisdiction like Des Moines, Iowa, and you're an immigrant and in this big position, certainly ICE would eventually go after you. And so they did. And according to the New York Times, it says here, ICE agents approached Dr. Roberts while he was in his vehicle on Friday, and he sped off, according to a statement issued by the agency. He was later taken into custody after his vehicle was found abandoned near a wooded area, the statement said. The agency said that he had a loaded gun, $3,000 in cash, and a hunting knife when he was detained. Now, it also mentions that he has a license to carry a gun. So I just want to make that point clear here as well. So now, let's say, for instance, we had a case like this. If we get a case with these types of facts, what would be our thinking and strategy? Well, first of all, we would want to locate him. We would want to make contact with him to see how he's doing, how he's feeling, and just make that connection and establish that attorney-client relationship. We would also contact ICE and find out, what's going on, what are their plans with him. Are they thinking that he should be held in a mandatory detention under a mandatory detention policy, so to speak, or not? So we would get some clarity from ICE as well. And then, of course, we would want to know, does he have a case that he has appealed? Did he ever appeal that decision with the removal order? Does he have an appeal pending at the BIA currently? Because last year when he got that removal order, he had 30 days by which to file an appeal. And he could very well still have that appeal pending. I don't know. We would find out, of course, right? And now, and if he does have that case pending, we would, of course, focus in on our advocacy to try to get him out of removal so that he could continue his appeal process back at home with his wife and the rest of his family. Now, the other thing is this. We would request his records from immigration, certainly, to get clarity on his background, his filing history, and all of that. We would also review his criminal record to get clarity on the gun possession charges that are on his record. We would also potentially consider an I-212 waiver, which would address the removal order, but advise him that at some point he would need to depart if he had not already departed the U.S. in the past and came back in, but he would need to depart and finish his process at the U.S. Embassy, in which case the embassy will instruct him to file an I-601 waiver, which would be his final waiver. And once that waiver is approved, he will be able to get his immigrant visa and return to the United States. Now, this is a lot of ifs, right? This is a lot. And so these are the stages, however, that some people will need to go through if they want the United States to be their home forever. If they're in a situation like this with a removal order and you're in ICE detention, you have to strategize immediately with a lawyer about what those potential strategies and steps will be. Otherwise, ICE will try to execute on this removal order and remove him right away. Now, nowadays, ICE is also not considering, I should say, any requests for a bond or stay of removal. They're very, very hard on these matters, okay? They are just not saying yes to most of these requests. So the lawyer that comes into a scenario like this one would need to strategize and get to work immediately to ensure that his rights are protected and that his options are very clear to him, and get a decision from him in terms of whether it's a go or not with these steps that I've laid out here. If he is deported, he can still return to the United States through an I-212 I-601 waiver process, which means that he would not have to stay outside of America for the full 10 years that would be required under this removal process. So we would, dive deeper. I hope that things work out well for him. I hope that, at some point we would know certainly what happened here down the road. So guys, comment below. Let me know your thoughts on this case. And I will see you in the next one. Bye-bye.